Welcome everyone to this is a joint meeting between the Essex Planning Commission and the Essex Select Board. Mr. Watts, the chairman. You guys normally do a call to order, so this is our call to order.
I'll call the select board meeting, our second one for the evening for April 27th, 2023 to order.
We have no changes noted in the agenda at this point. At this point, if you guys are ready, do normally open the floor to public comments, questions for any questions for items that are not on the agenda. And for folks online, if you could just raise your hand. And I see nobody raising your hand, so.
Recording in progress.
Got it. At this point, Andy?
Okay, move on to the first business item, which is a joint discussion between the two boards and a presentation from Taylor Newton from the Chittenden County Regional Planning Commission. The intent here is education for both boards and for the public with regard to how planning takes place, and also answer questions about transitioning from a ZBA model to a DRB. Taylor, go ahead.
Great.
Introduce yourself.
Thanks for having me. I'm Taylor Newton. I'm the planning program manager at CCRPC. I have a background in land use planning. I've been a land use planner practicing in Vermont for about 10 years on the municipal and the regional level. So tonight...
Hang on a second, please,
ahead.
Taylor. I need to double check our attendance. Is Tom online?
There is a person with just a phone number.
Is Tom Furlan on the line at this point? Okay, without that, I apologize, but that changes the meeting to a select board meeting. We do not have a quorum, so the planning commission is not officially sitting as a committee tonight, as a commission. We have 3 members only present. We were expecting a 4th online.
Okay.
We do not see them at this point. If he joins further on, we can continue, but until then, I have to cede the table over to you.
All right. So can we continue?
Yes.
It'll just be a select board meeting. I think that the content is still relevant.
Oh, I see Tom.
Tables have turned.
Okay,
Now we have quorum.
let's rewind.
Sure. Yes. I guess that would be a good idea. So I'll start with myself. I'm Andy Watts. I'm the chair of the Essex Town Select Board. And
Tracy Delphia, I'm the vice chair of the town select board.
Kendall Chamberlain, clerk. Kendall Chamberlain, clerk, town select board.
Ethan Lawrence, Town Select Board.
Don Hill Fleury, Select Board.
Greg Duggan, town manager.
Dustin Brusso, Chairman, Essex Planning Commission.
John Schumacher, BC member.
Georgia Levine, Planning Commission. Newbie, this is my second meeting.
Because we don't
sorry.
get any sent down here.
Okay, yes. Georgia Levine, this is only my second meeting, Planning Commission.
Tom?
I'm Ferland Planning Commission, but last meeting.
Huh.
My name's Kent Johnson. I work in the planning department, town planner.
And Catherine Sonic, I am the planning director or community development director.
okay, thank you. So Newton. Let's go.
Apologize for the interruption.
Yeah.
No worries. So I have a presentation to provide. And is that presentation going to be up on this screen here?
Yes,
Excellent.
I will.
So the presentation tonight is really just the nuts and bolts of municipal planning and land use regulation in Vermont. So off the top, we're going to talk about generally and very briefly planning, because I know we want to talk mostly about regulation. And we're going to talk about the roles and responsibilities of each municipal board as a part of the planning process and as part of the regulatory process. We're going to talk about taking the actual town plan itself and implementing it, both through regulatory means, so rules, and through non-regulatory means. And then we're going to talk through the basics of meetings, hearings, due process, open meeting law, those sorts of things. I can tell you I already have that down a bit by talking through quorum. So any questions before we kick off? Okay, let's get started. We can go to the next slide, Catherine. Sorry, just a title slide. We don't really need that there. We've been planning in Vermont for a very long time, at least since the 1920s. Vermont enabled municipalities to adopt zoning starting in the 1930s, but there really haven't been a lot of changes to statute over the course of that almost 100 years now. The last major overhaul of state statute was back in 2004. I wouldn't even consider the housing bill this year necessarily an overhaul of state statute. And so we're probably due for one next couple years. But this slide is really just to show you that the outline of what we're doing in terms of the planning commission roles and the select board roles have been around for about 100 years. Next slide. Why have a municipal plan? It's a good idea to generally have a municipal plan to guide what you want to achieve as a municipality. A lot of municipal plans are really focused on land use, focused on transportation, focused on public facilities, but they're comprehensive and can talk about almost any topic you want. We're going to talk a little bit about the required elements of a plan, the optional goals that are in state statute that could be included in municipal plan, but the real takeaway is you can talk about anything you want in terms of municipal plan. The municipal plan guides the work of the planning commission, but can also guide the work of the select board itself and the town at large. A lot of municipalities have actions identified in their plan that could apply to select boards, conservation commissions, any ad hoc committees you want to create. It's important when developing a municipal plan that you have a very broad, comprehensive public process. In Essex, once upon a time, you guys did Heart and Soul. It's a really good example of a very broad and comprehensive public planning process. Let's go on to the next slide, Catherine. When you have a municipal plan, you can do certain things. You can adopt zoning and subdivision regulations. You can also adopt flood hazard regulations. If you don't have a town plan, you can't adopt rules to regulate development. By having a municipal plan, development applications that are subject to Act 250 must comply with your plan. That's criterion 10 in Act 250. That projects must comply with both the municipal and the regional plan. Having a town plan also means that Section 248 applications, so those are applications for renewable generation facilities, solar facilities, wind facilities. It's a criteria in Section 248 that also says that those facilities must comply with your municipal plan as a part of their permitting process. It also sets up the municipality for not only having more competitive grant applications, but actually being eligible for most state grant applications. Municipal planning grants, you need to have a municipal plan. To levy impact fees, you need to have a municipal plan. So the municipal plan is really the basis for enabling the municipality to do a lot of different things from a regulatory perspective, and there's also the carrot of funding out there for you to implement your plan, if you have one. Next slide. So regions themselves are the RPC. We provide regional approval to municipal plans if it's sought by the municipality. And we make sure that the municipal plan meets statutory goals and policies, complies with the regional plan, but we also do something called confirmation of your planning process. We review not only the process to create your plan, but that you're allocating budget to planning purposes, that you're working with your municipality, neighboring municipalities and considering their plans as a part of your plan. And as I spoke about in the last slide, by having this plan, you're eligible for certain grants and the ability to levy impact fees. But the thing I left out was that you also need to have regional approval to do those things. And you also need to have your planning process regionally confirmed. And so these bullet points outline in statute what we need to see as a region in order to confirm your planning process. Next slide. Just a quote that you guys probably talked about something similar when you did Heart and Soul, which is if you're when it comes to planning, if you're not doing it with people, they think you're doing it to them. That's why it's important to have a comprehensive, wide, and probably long public planning process that you bring people along as you develop your plan, incorporate their ideas, show them how you've incorporated their ideas. If you don't do that, you're bound to receive some pushback. So just a healthier reminder here as a part of this presentation. Next slide.
I interrupt for a second.
Sure thing.
The public packet on Civic Court does not include this slideshow.
No, it came in afterwards, but
Okay.
yeah.
I was just trying to follow along, and I'm like, I don't have this in the public packet, so that was going to be an issue for
Yeah, it just it
it
came
being
in late.
warned on the meeting.
We have it here.
That was all.
Yep.
Is it printed? Yeah.
No, it is not, but we can print it. I'm just saying we're viewing it together.
Right. I just
And it should have been emailed. It was emailed to you.
Yeah, Ethan, I can forward
right.
it to you.
Shouldn't have been provided to the public though. No.
If we have presentations that come in on time, we try to include in the packet, but
Okay.
there's times when we don't, in which case we just present them at the meeting.
Well, the
Find
meeting
it-
is
I'll find it
being
in my
recorded,
video.
I know, so.
Right. Yeah. I was just curious what you guys were reading along. I saw Kendall's on the screen.
And we
so.
can post this up on the website after.
Okay.
Right, go ahead.
As you can see in state statute, there are a lot of different planning goals established by the legislature. They're really broad.
That's great.
They deal with everything from flood resiliency to childcare, to air quality, to the efficient provision of public services. These planning goals are optional. Most municipalities choose to meet these goals because these goals are required if you want to receive regional approval of your municipal plan. On the next slide, you'll see the required elements. These are required regardless of whether or not you seek regional approval of your plan. You need to have a land use plan and you need to have a future land use map. You need to have an economic development chapter. You need to have a housing chapter, or at least sections within chapters that deal with these issues. I won't go step by step, but just know that there are specific requirements you need to meet within each one of these categories in that specific statute, 4382. Next slide. Plans expire every 8 years. This is a change from a few years ago. It used to expire every 5 years. The intent behind changing it from 5 years to 8 years was to allow you guys more time to actually implement your plan. A lot of municipalities were feeling planning fatigue. They would start a planning process. It would take 2 years to develop the plan. They'd have a year or two to implement the plan. They'd start planning the next plan. And so the intent here is to provide more runway to actually implement your plan. And things change slowly in Vermont. So it also provides more time for things to change and to perhaps reevaluate what's happening in the community. Adoption, as you guys probably know, it takes a long time. It needs to be 3 public hearings here in Essex because you guys are an urban municipality, 1 of the Planning Commission, 2 with the Select Board, then you guys go to ballot to actually adopt. That is uncommon for a municipality of your size. Most municipalities just adopt via Select Board action. Plans go into effect upon adoption, unlike regulations, which we'll talk about in a sec. Go ahead, Catherine. Your planning staff knows this. If you're developing a municipal plan on your own, the Vermont Planning Manual is a really great resource. Would direct you there. I really like how it frames all planning topics within the framework of maintain, evolve, or transform, particularly in terms of land use planning. And I think it just provides an easy lens to have a conversation with regular folks in your municipality about different geographic areas in your town and how you want to see them either stay the same, change a little bit, or totally evolve to something different. Next slide. This is what I'm really here to talk about, roles and responsibilities. So, over the top of everything, and not just over planning, but everything, is the legislative body itself, is the Select Board. The Select Board has a say in each one of these subtasks, the legislative task, the quasi-judicial task, and the administrative task. Not much of a say, at least over quasi-judicial and administrative. We'll talk about that in a second, but a heavy say in the legislative function. Most of the legislative function is under the jurisdiction of the Planning Commission. And so that is writing municipal plans, that is writing municipal bylaws, that is doing the real heavy planning work and policy setting. They don't have the final say. Typically, those plans and policies and regulations, in almost all cases, then go to the select board for adoption. And so that's where the select board interacts with the planning process through the legislative function. I'm going to skip quasi-judicial, but through the administrative function. Let's stay with quasi-judicial for a second. The quasi-judicial function is essentially like a court. The DRB plays that function, or will play that function here in Essex. And so the quasi-judicial function is about implementing the rules adopted by the municipality. So select board adopts land use regulations, and then the larger applications go through a quasi-judicial proceeding before the DRB. The DRB takes an application, then applies the rules, and renders a written decision. You guys are used to operating under the PC ZBA model. That's where the PC has kind of a split role between the legislative function and the quasi-judicial function. But under the DRB model, all that is consolidated under one board. They are the board that makes all quasi-judicial decisions. The legislative body plays a role in the quasi-judicial function really in two ways. One is through the appointment of DRB members. Then two, it's also plays a role under appeal. When there is an appeal of a quasi-judicial decision, the select board is the entity that would make a decision whether, about how to interact with the appeal in front of E-Court. Go ahead.
I thought later in this presentation, it says that the appeal goes to the environmental court. That's
It goes to the environmental court. And so what I'm saying is that when that appeal happens to the environmental court, the town then, the select board,
right,
makes a decision about how to interact with that appeal before the E-Court.
Okay.
Because there's various different ways you could interact with that appeal. And we can talk about that when we get to that slide, though.
Okay. But to be really clear here, the quasi-judicial process is owned by
The DRB.
the DRB or Planning Commission. In,
Correct.
In our current case, if a resident objects to a decision that's been made by the Planning Commission in that realm, the
appeal is always to the E-Court. The appeal is not to the select board.
right. So right. Thank you. Thank you for the
Yep.
clarification.
Yep.
Yeah.
That's a little bit unlike other states. In other states, select boards, or city councils are typically involved in the quasi-judicial process. There's typically like a DRB that'll make a decision, then there'll also be the select board making a decision in sequence. That doesn't happen in Vermont. We just have all that power consolidated under one DRB. As an FYI.
So other than possibly changing regulations, but a decision is based on the regulations that are in place at the time that the decision is made.
Correct.
And that if there's some concern about those regulations, it has to go through the whole regulation.
The
update
regulations
process,
would have to be changed by
which
the
is
planning
then
commission, and
initiated
then
by the planning commission.
correct.
Comes back to the select board
Correct.
through multiple
Public hearings.
public hearings.
Correct.
Eventually gets approved by the select board, and then any applications that come in after the point that it's
Effective.
approved or whatever the effective date is, would then those new rules would apply. I
Correct.
just want to make sure that that's a clear,
Correct.
because that's a question that has come up to us. That's why I
Okay.
wanted to
Yeah.
walk through
The
that.
DRB makes decisions based on the rules that are in place. Full stop.
In
And,
today's world, in our model that we currently have, PC does that, performs that role
Right.
in addition to the planning model. The applications that come in are
Yeah.
reviewed with the regulations in place, unless it's a continuance or a amendment, and then the regulations that were in place at the time the original application was. It gets a little muddy.
It gets
It's a-
complicated in terms of timing and with vested rights, depending on how many sequences of public hearings you have in terms of prelim final too. And I am not a lawyer,
Yeah. Yeah. Right.
but yeah, it can get complicated. And I think, things particularly get complicated in Vermont too around the fact that, when new regulations are warned by the select board, staff and the DRB, actually, let me take that back. Staff, not the DRB. Staff has to review every application submitted to them under two sets of rules, under the existing rule and under the proposed rule. And so that gets complicated. And then, let's say the rules are adopted by the select board. Then there's an effective date 21 days after that. And so then we go back down to one set of rules, the existing rules. And then it's how statute is set up. Doesn't make a lot of sense, but at least that's my interpretation of how those things work. All right, now that we're all thoroughly confused about how the rules work and the effective dates, the administrative function is performed by the zoning administrator. The zoning administrator is the person who's actually implementing the rules on a day-to-day basis. They're the ones that are taking for the larger applications, taking the DRB decisions, and then actually that same applicant will come in for a zoning permit to, let's say, build a commercial structure. They're the ones that are making sure that that zoning permit application complies with the DRB decision and the rest of the bylaw. With let's say a single family home, that's not something that's going to go to your quasi judicial body. That's going to go right to the ZA through a zoning permit. Same deal. ZA is making sure that that single family home, the zoning permit application complies with their rules. They're administrating the bylaw. The legislative body plays a part in this just through appointment of the ZA itself. You guys make that appointment. ZA can't be removed. ZA can be removed, I think, for cause after a public hearing. It rarely happens in Vermont. But the ZA really is supposed to act as an independent entity administering the bylaw. Any questions on roles and responsibilities? Okay.
Hang on. Check online real quick. Tom, any questions? Sorry,
Nope, I'm good.
forget. Okay.
Just a note on regulation, bylaw, or ordinance. We use these terms interchangeably in Vermont, but they all mean something a little bit different. So I just want to note that. Regulation is a broad term. It can apply to any kind of rule, either through an ordinance is a regulation or has regulations in it. A bylaw has regulations within it. A regulation just refers to any kind of rule. There could be state regulations, federal regulations. A bylaw is actually something specific. And in Vermont, whenever you have rules related to zoning, it has to be a bylaw. And the big difference with bylaws, and the real big difference between bylaws and ordinances, is that bylaws have to allow for grandfathering. They have to allow for things that are non-conforming under your new rules to continue to exist into perpetuity. And with an ordinance, that's not the case. Ordinances don't allow for grandfathering. Let's use the case of a noise ordinance. Select board adopts a noise ordinance, then everything must come into compliance immediately. Select board adopts maybe a separate sign ordinance.
Except for shooting ranges.
So I'm gonna let that sit there.
Don't want to take a shot at that one?
I don't want to take a shot.
Thank you.
That was good. Didn't expect puns tonight.
You haven't been to a planning commission.
But that's the big difference between bylaws and ordinances, is that bylaws, there's grandfathering. Ordinances, everything must come into compliance immediately. Next slide. Implementing the municipal plan. We implement the municipal plan really in two different ways. We implement it through regulatory implementation, creating rules that folks must follow in town, and through non-regulatory implementation. That's typically through, creating some sort of planning process, creating some sort of plan, figuring out how to doing a bike walk master plan, doing a sidewalk plan, doing a scoping study for some piece of infrastructure you need. That's non-regulatory implementation. I'm going to focus first on regulatory implementation and particularly zoning rules. Why have local land use regulations? All these reasons come right from state statute. And you'll see if you put this slide right next to the slide that was about state planning goals, they pretty much match. It's about having compact development surrounded by rural countryside. It's about making sure we're not fragmenting farmland in our rural areas. It's about making sure that our urban areas are safe to all modes of transportation. Next slide. Local regulation is limited by a few different things. I'm first going to talk about the second bullet. Vermont is a Dillon's rule state. Does everyone know what that means? Okay. So a Dillon's rule state is essentially a state where the legislature holds all power. And the legislature determines exactly what powers are then delegated to municipalities. And so, in the circumstance of zoning, the legislature has delegated certain specific powers to municipalities in terms of how they can regulate development through zoning.
Yeah, I always describe Dillon's rule as the state tells municipalities what they're allowed to do, as opposed to a home rule state where municipalities can do whatever they want unless they're told they can't.
Correct.
And so we can't just arbitrarily do things. We have to have permission from our legislature to do them.
Correct. And with zoning and subdivision, the legislature has provided a pretty clear framework of the rules you need to operate within. You don't have carte blanche. Select boards have pretty broad authority, not with zoning or subdivision, but have pretty broad authority generally. But PCs, their authority is very specific in state statute. DRBs, it's very specific in state statute. ZA, it's very specific in state statute. So you're limited by what statute enables you to do as a municipality. Land use regulations are also limited by the 5th and 14th Amendment. Again, not a lawyer, but 5th Amendment deals with due process, both in terms of procedural due process, making sure that the process outlined in statute is followed, that folks go through that sketch plan, that prelim, that final, however whatever you've created in terms of that process, in terms of your bylaws, and also in terms of regulatory due process, making sure that folks are actually following the rules as they are written. 14th Amendment deals with equal protection under the law, and that's just making sure that folks are all treated equally by the regulations themselves. You're not making arbitrary decisions that are not based on the regulations or treating parties differently. The main way that we kind of explain the limits of what municipalities can do in terms of local zoning is through 24 VSA 4412 and 4413. So I would direct you there if you want to get specific about what statute says and what you can do as a municipality. Next slide. Go ahead.
Is that statute what determines the reasonable use of the property in the end? Or is it the town plan?
Adopting a zoning regulation would be the municipality's attempt at defining what reasonable use of property is. Yes. And then the court may, if there's an appeal. But generally in Vermont, if you allow a camp or a single family home, that's deemed to be a reasonable use of property. There are exceptions to that. There's a lot of case law around like floodplain and municipalities, barring or prohibiting development in floodplain, from a public safety perspective. And that's been generally upheld, even at the Supreme Court level, national Supreme Court level. So the administrator is really the clearinghouse of all development applications in town. Might be a little bit different in a larger municipality like Essex. I think Catherine might get some as community development director, but really the going small town Vermont, the zoning administrator is the one that's going to receive all the applications. And the zoning administrator is going to determine whether or not the application they received is administrative, that the ZA themselves has the authority to approve those applications, or if the application needs to go through a quasi-judicial hearing process. It's typically pretty clear. Your bylaw itself is going to talk about what land uses can be approved administratively and what needs to be subject to a site plan application, a conditional use application, a subdivision application, etc. The ZA is the person that makes that decision. Administrative applications, let's talk about single family homes again. In most circumstances, those are administrative. ZA is going to take that zoning permit application, make sure that that home complies with setbacks, complies with any other, general regulations you may have, wetlands, coverage, lot coverage, building coverage, height, those sorts of things. If they deem that the application complies with your rules, they're going to issue the zoning permit. If they deem it doesn't, they will deny the zoning permit application. In the case of administrative applications, parties can appeal that decision, and those appeals go to the DRB or the ZBA under your current model. With quasi-judicial applications, and we'll talk about examples of that in a second. With those applications, the DRB reviews those applications. You guys have staff, so you guys have staff likely do a review of that application, provide a staff report to your DRB. DRB is the one that actually weighs the application against the rules and renders a decision. That written decision has to be in writing, then can also be appealed. Whether or not it is issued or denied. That appeal is to the state environmental court. Any questions on process?
What are some examples of the quasi-judicial application?
Next slide, I think we'll go right there.
All right.
Yeah, we're going to go right there. It's going to take me a second to
I
get
should
there.
have waited, sorry.
No, that's all right. That's all right. That's just foreshadowing. So before I talk about that, exactly, I want to talk about land development. Land development is a definition in state statute. And it's this. And if you read this, it's everything. Everything is land development. You can regulate almost everything under zoning. A lot of things you shouldn't regulate under zoning. We can go talk about examples of that. But this definition is really broad. And I'd like to talk about this definition because I think it's really important to realize the breadth of power under zoning. And next time you're revising your regulations to look specifically at your exemption section. There are a lot of small things that probably meet the definition of development that happen all the time that you may not regulate. We can pick on Milton because Catherine and I used to work in Milton. And so two things in Milton that always bugged me was driveways and like stoops, like accesses to homes. For this definition, both those things meet the definition of development, literally. So me as ZA, I'm reading the rules and feel like I need to issue a permit. I have to issue a permit. It's but kind of through tradition in Milton, they didn't issue permits for driveways. They didn't issue permits for stoops. And so you should have put up more of a fight about that, but I was young. And so I just followed tradition. But the reality is, those are driveways we can maybe argue about, but with like stoops, just put them under the exemption section. Playgrounds, another good example for technically land development. Does anyone really want to go through the process of like permitting? Is it like a playground in someone's backyard? Probably not. Just exempt them under local.
There's an exception to that though, because if you're talking about a playground, that might be a municipal playground. So you're addressing impact by noise, by intrusion onto neighborhoods and so forth. So we've had both.
Okay.
So I don't think you might have to clarify what the exemption is.
Small accessory structures, small sheds.
Yeah.
A lot of municipalities have exemptions for like 100 square foot sheds or smaller because it's a de minimis impact. So just look at that exemption section. Sorry, rant on that over. All right, so there's various different kinds of applications, or types of review that can happen. The simplest type of review is a review of a permitted use. So this is back to the single family home again. Small accessory structures. This is a use type or a type of structure that can just be that's permitted by right essentially. As long as you comply with your setback rules and your general regulations, the CA can approve them because they're essentially established by right. Everything else on this list is an example of a quasi-judicial application. Start with conditional use. Actually, I'm going to talk about conditional use and site plan together because they often get conflated, and I think they're actually very different. Conditional use review is supposed to review the use of the land, not the structure itself, but the use of the land, and whether or not the use of that land is compatible with the surrounding neighborhood. It's about assessing a proposed use and how it fits within the context of the surrounding neighborhood. It's about the impact on everyone else. That's what conditional use is about. Site plan is internal. Site plan is about reviewing the physical site itself and how it is designed. It's not concerned with how it impacts the neighbors, really. It's not concerned about traffic impacts, really. It's concerned about where's the curb cut, where is the parking, is the parking wide enough, is there pedestrian access to the building, Is there landscaping? Is design of the site? A lot of municipalities use these two different application types interchangeably, but the criteria are really different. I think it's important to remember that. Both those applications, though, go to the DRB.
And in our case, since we have the ZBA,
Mm.
the ZBA looks at conditional use.
ZBA looks at conditional use, and then Planning Commission looks at site plan, which is inconvenient if you're an applicant. Variances. You should probably never issue a variance. A variance is a exception to a rule, essentially. And in state statute, there are 5 different variance criterias. And they're written so strictly that it's basically impossible to meet them. I know some municipalities issue them, but when I read those rules, they're so strict that there's really no way to get through that process from my perspective. But there is an alternative way to provide relief to property owners that are in weird circumstances, and that's through a waiver. And so a waiver is a process by which the DRB can grant an applicant relief from a certain standard under a specific condition. And so the easiest example is to say, is to use an example of like a small lot. Let's say you're in a zoning district where the minimum lot size is an acre, but you have a pre-existing lot that's only a quarter acre. And let's say your setback standard is 200 feet from the front setback. That might be hard to meet on a 4th acre lot. 200 feet setback might be impossible. And so this is an extreme example, but in this circumstance, you may have a specific waiver process in your rules that says you have an existing small lot in this district. We can reduce your setback by 100 feet or by 50% or by whatever. But you're talking about a specific condition with a specific, relief that's enabled. You're giving the DRB very tight rules to exist within. Not giving carte blanche, but you are allowing that property owner some relief under specific circumstances.
So in that waiver situation, it's best practice would be to have the conditions under which you can approve a waiver specified in your regulations.
Yes.
For example, in our case, we have 50-foot buffers between properties in one of our industrial zones. There's an authority of the Planning Commission to waive that 50 feet with conditions.
Yeah.
And we do that.
Yeah, good example of that.
It's specifically in there, gives it the authority to do that. We have 200-foot buffers too that are not allowed to be waived.
Got it.
This would come into play as well with the residential. We've got a lot of old stock residential, and in many cases, the foundations are 30 to 35 feet from the road, which doesn't meet any setbacks. So that basically, without any sort of a waiver process, nobody can do anything on the front of their home.
And that may be something you want. It may be something you don't want. It's up to the municipality to decide. But that could be, a circumstance where you're like, oh, this doesn't make a lot of sense. Let's create a waiver process. Yeah. Here's how I'll transition from that conversation. It's about if you have a lot of conditions in which you're like, we need to create a waiver. I think that's a telltale sign that you should probably just reassess your zoning, period. Yeah. Working with the town of Georgia a few years ago, and we started down that track where we had 3, 4, 5 different kinds of waivers we were talking about. Just reduce setbacks in this district by 5 feet, and it doesn't really matter. It doesn't change the character of the area. And so, if you end up on that track where you're talking about a lot of different waivers, maybe just write your zoning to better fit what the market's demanding or what fits the character of the area.
We got to be aware of the unintended consequences of reducing setbacks in areas, R1 zones where we have a larger. I mean, we could all of a sudden start seeing a huge increase in development where we aren't looking for it. But there's a lot of moving parts to this.
Doing it for 10 years, I'm less scared of change. But I hear you. I get it. Whenever you're changing any rule, you got to have those conversations about what those unintended consequences are. And
going with your eyes open, I guess, is
definitely
the suggestion.
I'll talk about PUDs now, and let's talk about PUDs and subdivisions together. Kent's already heard my PUD rant. I've kind of promised myself I won't do that tonight. We'll talk about it a little bit, but subdivisions and PUDs are both processes by which typically the property owner is subdividing land into different pieces. Subdivision is the traditional way to do it. So you got 100-acre tract of land. The minimum lot size in the district is 1 acre. You get 100 lots, give or take. You get some roads in there, you might get less, but that's generally what you get. And so you're following the rules very strictly in terms of minimum lot size, and you can divide land. PUD is a process by which you can divide land, but you can seek waivers from the DRB that allow for more flexible design. Typically, those waivers are not as structured as the waivers we've already talked about. Typically, they're more carte blanche, and typically they're baked into standards where it's like the point of the DRB is, the point of a PUD is to, have some land set aside for conservation, maybe at 50% of the original tract, and it's to kind of have compact development over here and to minimize road length, but the structure's pretty unstructured. And so in your rural areas, this might be a good tool still to provide the property owner, but you're really allowing the property owner to drive the bus in terms of how things are designed. And some municipalities like that, some municipalities may not, but you should go into that eyes wide open. It creates a situation where the DRB has to make a lot of decisions with not a lot of structure. And a lot of DRBs don't like that. DRBs like to see the rules and implement the rules. PUDs, there's not as many rules. And so, sorry, I'm devolving in my rant. I'll stop.
No, you don't have to stop. This is all.
Don't have to stop.
I think. Sorry, I'll do one other part of my rant. I'll lay off the rural areas. Rural areas, they might still make sense. I can concede that. I think there's better ways to do it. That you can kind of mix subdivision and PUDs in a more structured way. But in urban areas, that's where I really think PUDs make no sense. In a lot of, I don't know about in Essex, but in a lot of smaller Vermont municipalities, they'll have rules that say if you're going to have more than one principal structure in a lot, you have to do a PUD. That's a bummer from a couple different perspectives. One, PUDs typically are a 3-step process. Sketch, prelim, finals. The process can take forever. Also, you look at our historic downtowns, villages, historically, oftentimes there's more than one principal structure in a lot. It's happened historically. And so we're creating this really difficult process to get through when we're also saying we want to kind of recreate what we have done historically. So you're also kind of going against the original intent of PUDs and state statute, which is really about conserving open space for forestry, for conservation. And so, in urban areas, I don't think PUDs really make any sense. I just think you need to rethink your zoning. I think you need, first off, just allow more than one principal structure in a lot, or allow it through some sort of simplified waiver process that's one step, and under certain conditions. So yeah, stop there. Any questions on PUDs? I can keep going.
We struggle with PUDs.
Yeah.
We have, and it's been one of our hot topics for our revisions. One of the most recent times that it came up, we often feel like it is an attempt in some areas by an applicant to circumvent the rules.
Yes.
Yeah.
So that I think is clear. But it's also there are times when we're trying to see if we can use it to enable something, such as tiny homes. Because we worry about the banner of spot zoning.
Yeah.
So we don't want to necessarily change all of R1 or R2 zoning across the board when it might make sense for certain areas and certain parcels to be able to support tiny homes somehow. But that's where we're looking at PUDs as being an enabler instead of something to be a way to bypass rules and regulations. So I mean, it's an ongoing debate. It has been an ongoing debate in the Planning Commission for quite some time.
I think, there may be ways to rewrite those rules in a way that allow for certain, multiple principal structures on one lot or lots, certain sizes. That's one way you can do a PUD. Can't do a PUD. Circumstances you want to prevent. You can get more specific. But one other thing I'll add is that PUDs are nightmares for staff because typically PUDs have like 8 billion conditions on them and waivers from all these different lots and building envelopes, and to track those things over time, really hard, really complicated, giant time suck. I can think of some PUDs in Milton that were like 6 years old, and we were in like the 11th Amendment, and like it's impossible to understand what's going on. I mean, Catherine and I had like giant spreadsheets trying to figure out what conditions were still applying. It can get really hard, and you don't typically have that with more conventional subdivisions. It's usually much more cut and dry.
Yeah.
Any other questions on types of development review? The one other small rant I'll go on, well, if no one has questions, is about conditional use. I don't know about Essex. I don't know your rules very well. So, only 3 years back in Chittenden County after being up at Northwest Franklin County. But I think conditional use in Vermont generally gets overused. I think a lot of municipalities work hard on conditional use for things like retail, like in their downtowns, which is you want to promote, that are typical of a downtown. And from my perspective, that's a bit of overregulation. You're still going to have site plan review, typically. Still going to go to the DRB. You're still going to make sure the site's designed well, but that's the kind of use you want to see in your downtowns. Same with like restaurants too. You see that a lot in small towns. I don't think it's needed anymore. If there's no other questions, we can go to the next slide. So when the DRB does make a decision, it must be in writing, and it has to contain 2 things: findings of fact and conclusions of law. A finding of fact is easiest way to talk about this is through giving an example. A fact is that the application is for development at 50 Main Street, that the parcel is located in the R1 zoning district. That is a fact. A conclusion of law talks about how the application complies with the bylaw. So the conclusion would be that the applicant listed a 50 setback that complies with the minimum setback standard of 75. Got to base your decisions on the bylaw itself, nothing else. Not your feelings. It's about what the bylaw says. Minutes may suffice as a decision. Don't do that. Don't do that here in Essex. You guys do written decisions with conditions. That's a much better structure for a larger municipality. You don't have to reveal how the board itself voted in terms of individual members. You just have to memorialize a concurrence to the majority. You guys have the 7-member board PC, so 4 voted in favor of something, 4-3. Big point I want to stress is that DRB. I'll just say DRB for the sake of brevity. You don't have to make You don't have to make a decision on the application the same night that you hear the application. You do not. And I think we're going to talk about process in a little bit, but you can always continue a hearing to another date and time if you need additional evidence. That's a really important tool in the DRB's tool. You need to issue a decision 45 days after the close of the hearing, and there's a 30-day appeal period after that. Here in Essex, I imagine staff's responsible for writing decisions, and DRB is the one that kind of reviews it, make sure it works.
We generally will craft it with staff during the meeting, and then staff will do the final preparation.
Yeah, it's based largely on the staff report that staff
Right.
has prepared. But then the planning commission will add additional findings or
So the within 45 days is triggered by the end of any hearing, whether it's continued or not.
Correct. Yeah.
It's
from the
not
close.
it's not from date of submission. It's
Correct.
from closing of
Correct.
final close of hearing,
Close
Final
hearing.
public hearing.
public hearing.
So if the
Right.
public hearing is open, the clock doesn't start.
Correct.
And it's a point we often make that if we continue, we frequently will not close the public hearing.
Yeah.
Until we're ready to either do a final deliberative or make a decision. So we'll keep the public hearing open so that start.
Okay.
We'll talk more process in a bit too. Next slide.
I got a question about that. So you can leave a public hearing open when there's no meeting in progress
Essentially
how
continue it to
long?
the next
Continue.
meeting.
forever.
Ethan, this is a question I always get. There is no limit in statute.
Okay.
And
I
so
want to make sure I was hearing that right.
Oh no, you're hearing that right.
Okay.
Yeah, there is that statute doesn't say like you can't continue past 120 days. There's no limit on that backside, and that's property owners get a little jittery about that, right?
Has that ever been brought to court?
I don't know of any case law that about that.
Yeah.
I'm sure it has, and I think a property owner would have a pretty easy. I think if a property owner like brought an injunction after like a year, they'd have a pretty easy case, and I bet
Right.
they'd probably some sort of mediated settlement or something. Then the DRB would make a decision before it even went to court or something like that. But but yeah, no, there is no limit outlined in the statute. All right, we've already talked about appeals a bit, but decisions of ZA, the administrative officer, that goes to the DRB. Any decisions of the DRB, that's an appeal to the environmental court. Any appeals of environmental court decision go to the state Supreme Court. Next slide, maybe. Yeah. All right. Only interested interested persons can appeal. Not just anyone. And so statute outlines specifically who are interested persons. The applicant, town, be represented by the select board, property owners in the immediate neighborhood. That's not just the butters. Immediate neighborhood, which is not defined.
I was going to ask you how they define the immediate neighborhood.
Not defined. The e-court will make a decision whether or not someone is or in the immediate neighborhood. Any petition of 10 persons that might be coming out statute for what's the last version of the housing bill that I just saw. The state, ECCD. And you have to participate at the DRB level, either through written testimony or through verbal testimony in order to maintain your status as. You can't not go to the DRB or issue or provide testimony to the DRB, then appeal the decision later. You have to establish yourself in the DRB process in order to appeal to environmental. So DRBs can, as a part of their process, determine who is an interested person and who's not, as a part of their public hearing. Most don't. Most just allow anyone to talk if they want to talk, and they let the e-court make that decision later about whether or not someone truly is an interested party. They truly have appeal rights. There are some DRBs that do decide. Really, your preference, attorney. I think it's easier just to let everyone talk. Only talk to their 5-minute limit or whatever you have, and kind of defer that decision on whether or not they're truly in the party or not.
So you can't just attend the meeting. You can't just be a participant in the meeting.
If
you need to actually speak on an individual application.
Good catch on your part. You can attend the meeting and sign in, and I think that is sufficient in order to establish your right. As not need to, I guess, technically provide verbal.
Thank you.
I got a brain picker for you. If a large group, in our case of the town, got together a petition and petitioned the select board to appeal.
They would do it on themselves. They would petition the select board. They would.
But could they?
A group of 10 persons or more.
Well, ours is like I forget what it is. 15% registered voters. I was just curious, and I don't know if this has ever even happened. But could you get a 15% to petition the select board to appeal the?
You just need 10 people to appeal to the
DRB decision.
That's gonna be removed
to the environmental court.
So two things. So the 15% rule that you're talking about, can, I'm going to take away the percentage for a second. In the statute that talks about adoption of town plan, and in the statute that talks about adoption of zoning bylaws, both those sections talk about X percentage of towns or voters can petition to, after select board adoption, let's say, bring those documents to voters. That's one thing. So that's kind of like a legislative petition.
Right.
This is a quasi-judicial petition, and so it's a petition not to the select board. It's a petition to the DRB, essentially saying we've got 10 or more of us. We're now an interested party as a part of this specific application, and they can establish those rights to the DRB and therefore then appeal to the E-Court. Does that make sense?
Yeah, but you said that that's going to be removed. Possibly?
Right in two different versions of the House
Right.
bill, right?
Yeah.
There's the Senate bill and there's the House bill. In the House bill, that has been removed. And actually now it says like one person, you have to be an aggrieved person, and there's definition to an aggrieved person, another piece of statute. I don't know enough to tell you more than that, but I do know that the 10-person number is gone.
Yeah, I was just more of a question to any petition brought to the select board by the people of Essex. Could they ask the select board to appeal something?
A planning commission decision, it would have to go to environmental court.
Because the
Yeah,
environmental
select board
court
has
select board has no say in whether something, well, we can.
Well, it says you can appeal.
The select board,
appeal.
the municipality can choose to appeal something.
Right.
Right, but then we would be appealing something that our own planning commission decided.
Right.
And there's no section of statute that
That
says
covers
that
that.
if select board receives a petition of X number of voters, it shall appeal a DRB decision or a PC decision. That doesn't exist.
And so what he was referring to before is if we approve a zoning regulation, we have a petition to have us have that zoning regulation approved by the voters rather than just the select board. That's what can be petitioned.
Yeah, I get that. I understand that section, but I was just curious to our charter that says any petition brought forth shall be.
Our charter doesn't say anything about that.
A petition?
That's statute.
You can petition, but it's typically more
it's-
around starting an ordinance.
That's
or
ordinances.
having a
Yeah,
vote.
that's
on-
just-
Okay, so it's
vote
clear
on
in there that it doesn't
This applies to
include certain
ordinances.
things.
Right. These are not ordinances. It's just planning commission
Quasi-judicial
bylaws.
decision versus normal.
I was just curious about how that correlated with the charter.
Yeah. And you said earlier that the select board is involved in an appeal because likely we're paying for the lawyer on the
Yes. Yes. And so let's talk about that for a second. Select boards typically get nervous about appeals. I don't think you need to, really. You guys just decide how much you want to interact with the E-Court process.
Mhm.
A property owner could appeal a DRB decision to E-Court, and you guys could just be like, all right, good luck, see ya, not spend a dime. You don't have to interact with the process. There's some statutory requirements for staff in terms of providing information to the applicant, providing information to E-Court, but you don't have to actively defend a decision at E-Court. It is really up to the select board, hopefully in consultation with the DRB and with staff. But I'll use an example with Act 250. RPCs are parties to all Act 250s in Chittenden County. And so, a recent appeal in South Burlington. We just didn't decide to actively defend our decision at E-Court. All we did is just tell our attorney, can you just monitor what's happening? And just tell us down the line as different motions are filed if we should become a more active participant. And so that can also limit your expense at just monitoring proceedings. Active. So just want to note that because it isn't like you get an appeal and all of a sudden you're in the tank for $30,000 because someone appealed to you. It does not have to be like that. I think on the next slide, it's been a while since I've been. Oh no! All right. So sorry. Go ahead. I was going to talk about de novo.
Okay, yeah, I was gonna just make a comment about appeals and try to draw on my knowledge, which is a little bit fuzzy. But if there's an appeal, a lot of times it's based on project being approved or not approved based on the regulations. And my understanding and memory is that if you have pretty clear regulations and a project was denied or approved based on those regulations, the
Got a pretty
appeal,
good shot.
the PRB, the planning commission, the select board has a pretty good shot to win in court. JM Golf is the famous case I always remember hearing, and I think it was South Burlington, and I think that the city.
Still being appealed to this day.
Oh, is it really?
Oh,
Okay.
different sections of a PUD actually. Yeah.
But my memory is that the city lost the appeal in that case, and it's because there were not clear standards. They had denied a project based on some kind of vague standards in the town plan, and so
The gist of that case is essentially that the city had vague environmental protection standards, and the DRB did what they could with those standards and made a decision, but the court found essentially those standards were not specific enough, too loosey goosey, and remanded the case, I believe, back.
okay. So the message and takeaway is basically the clearer your standards, the safer you are, the better you are, the more likely your
You're going
decision
to
is to
win, or
hold
no
up in
one's going to
court.
appeal.
Yep.
And the other thing with appeal is that you guys are not on the record, correct? You guys have not.
Right.
Right. So, all appeals from the town of Essex would be de novo at e-court. And so that all that means is that all the evidence gathering starts all over again. Some municipalities have adopted something called the MAPA, the Municipal Administrative Procedures Act. Shelburne is one. Shelburne's actually going to repeal it. I think Winooski, and essentially what MAPA does is it creates a much more structured for evidence taking at the local level. It requires like a transcript of proceedings. It's much more structured and at the DRB level. Some municipalities like that because when they go to appeal, that entire record goes with the appeal. So appeals can be adjudicated faster, and the e-court takes directly into consideration everything that happened at the local level. I don't know if there's really pros and cons to, I don't know, that you want to consider about changing your process. MAPA is hard to get a paper transcriber. It can be expensive, and things may work fine as they are already. But just want to note that one difference. All right. Zoning. This document, Zoning for Great Neighborhoods, came out of a collaboration with ECCD, the Vermont Realtors Association, ERPCs, who else? A bunch of folks involved in planning. ARP was the big one, actually, big funder. You're right. And this document was developed by the Congress for New Urbanism, and it looked at municipal zoning on a bunch of different sizes and scales in Vermont, different case studies. Fairfax was the community I was working with at the time, and looked at how we're doing zoning in Vermont, looked at national best practices, and provided a pretty good menu of options about how municipalities can right-size their zone better fit, specifically like neighborhood and village contexts. This guy's awesome. If you hire a consultant, they're probably going to guide. So if your staff's writing zoning or rewriting zoning with the planning commission, I advise you guys to follow this specific document. Source gotten. Non-regulatory implementation. So we talked a bunch about rules. So, I tend to talk a lot about rules. There's a lot of different ways to implement your plan that aren't rules, that are more fun. One way you guys do that here is through capital budgeting. Town plan probably talks a lot about like municipal facilities, what police department capacity, fire department capacity, what you need for public works equipment. Capital budget is the way that you implement your plan. Through creating rules, but through doing budgeting. I'm going to come back. Tax stabilization contracts, purchase or acceptance of development rights. Some municipalities have something called the transfer development rights system. Essentially, you can sell development rights in a rural area and send them to a more urban area. And so, the developer in the urban area essentially gets a bonus. Don't recommend this on a small scale. You guys are still pretty small, even though you're over 10,000. So these are difficult systems to implement. I think they should implement probably more on a countywide basis or statewide basis, but you're unable to do that. South Burlington does this, Stowe does this. They might be the only two in the state. The big way you implement your plan in a non-regulatory way is through supporting plans. So scoping studies for sidewalks, master plans for sidewalks, ETC next, you know, anything where you're not creating rules, but you're studying how to refine your planning down from the comprehensive scale town plan into something more specific over a smaller geographic area or a smaller topic area. Other projects and studies, you know, that might be doing a demonstration project for how you want to redo a street section. Work with local motion, get some hay bales out, get some paint out, and figure out if, you know, you wanted to redesign that street section with bump outs and a sidewalk and plantings, those sorts of things. Doing educational things with the school, those sorts of things are fun ways to do non-regulatory implementation. No one really talks about tax stabilization contracts, but that is actually a majority of the select board. You guys into contracts with property owners. You guys do that
Yeah.
a little bit? Okay.
Yeah.
Great. To incentivize certain things you want to see done. Typically, I see municipalities do that for like economic development reasons. Helpful resource. We have a funding opportunities database on our website that is a giant list of grant opportunities specific for municipalities across a huge array of topics, from land use, water, sewer, the whole shebang. So if you haven't looked at that, I encourage you to look there. We're gonna skip right past this, Catherine.
Yeah.
That was from new planner training. We're not gonna talk about that today. In terms of implementing your municipal plan, this resource is really dated. It's on vpic.info, Vermont Planners Information Center. There's an implementation manual. Talk about all the different ways you can plan. It's from 2007, but it's a great resource. All right, so we're through the first three modules. Now we're going to talk about meetings, hearings, and due process. I think you guys probably know the deal here, so I'll move quickly. So a meeting, it's whenever you have a quorum of a body. We had to wait for 4 today for the Planning Commission. Hearings happen within meetings. There's 2 different kinds of hearings. There's legislative hearings and there's quasi-judicial hearings. Legislative hearings are held by the Planning Commission, by the Selectboard, and they're about receiving, the whole point of them is to receive public comment on some sort of public document, town plan or a zoning bylaw typically. Quasi-judicial hearings are about specific development applications, where the DRB is essentially acting as a court to ensure that the rules are followed. And the point of that hearing is to receive public comment from interested parties and from the applicant to ensure the application complies with the rules. Any questions on meeting versus hearings? Basics of open meeting law. Got to have advance notice. We'll talk in the next slide about timing on that. But agenda before the meeting at the municipal office, 2 other locations in town. Website if you have one. In a meeting, you have to allow at least one opportunity for the public to participate in the meeting. Typically, that's the public comment right off the top of the agenda. Make minutes available within 5 days and address any complaints you receive about violating law. DLCT has a great resource on open meeting law if you want to brush up. There's a public notice, regular meeting 48 hours, posting 2 other places besides the town office. Legislative hearings for plans and for bylaw amendments. Actually, plans, I believe it's 30 days, not 15, but for regulations, it's 15. There's an error there. But you also need to warn that hearing in the newspaper of record. I don't know if you guys do your local paper, Essex Reporter, if you do the Free Press or 7 days or what you do, but got to be in one of those. You also need to do certified mailings to specific parties, and so specific parties with legislative hearings typically are PC chairs of adjoining municipalities, the RPC, State Agency of Commerce Community Development. Quasi-judicial hearings. Warnings for quasi-judicial in state statute, they vary from 7 days or 15 days depending on application time. Do you guys vary in your local rules as well, or you guys just do 15 days for everything?
I think we vary.
Very. So 7 days probably for site plan and maybe sketch plan subdivision.
I think our consent agenda is 7. Anything else, 50.
There's a historical context for that.
I'm interested to hear more at a later date. Some municipalities keep it simple and just say every DRB application is going to be 15 days. Newspaper record 3 or more places, not 2, 3. Why is there a difference here? I'm not sure. It just is. It's the state statute. You have to mail notice to applicant and then to adjoiners. So here's that weird difference where like you can be an interested party if you live in a general neighborhood. Only the direct adjoiners get notice. Again, not sure why that's different. There also needs to be posting on site on the actual property within view of the public right of way. Doesn't matter if you live way up a driveway, you got to have the posting within view of the public right. Any questions on notes? I had to mend the flow a little bit because you guys have a little different flow here in Essex, but here I'm kind of replicating how a DRB hearing should be should flow in it. Chair opens the hearing, staff does an overview of the staff report, board members ask staff questions, applicant addresses questions, board members ask questions of the applicant in terms of how the application conforms or does not conform with rules. Then there's time for comment of interested parties with the general public. You're allowed the general public to speak. And then PC staff, applicant addresses public comments. PC deliberates. It sounds like you guys deliberate in public, not in private. And then PC works on the written decision in deliberative session, but in private. Sounds like in Essex. Staff final decision, and then PC signs. So a couple things here on flow. One, you don't have to deliberate in private, in public. You can deliberate in private. That's fine. I don't see any. You're certainly allowed by the rules to do it. I think it's actually good practice, particularly with like really controversial applications. Private, juries do that all the time. So I wanted to note that. I also wanted to note that it's really important that you note that to enter into deliberative session, you have to close the public hearing. So that starts your clock, right? That starts your 45-day notice or your 45-day period. And so before closing that public hearing, I think it's really important for the board chair to ask the question of, do we have enough evidence to close this hearing or not? Should we continue it to another date and time and then ask for other evidence before we render our decision? It's important that they do that because DRBs are not really supposed to reopen the hearing. Generally, not best practice to do that. Or you can do that if like new evidence comes to light, or through reconsideration. Again, not a lawyer, but generally best practice. Keep the hearing open until you have all the evidence you need in order to make a decision. Keep the process simple that way.
I would say we probably have used a deliberative session maybe half a dozen times in the last half a dozen years. And it's primarily it's an open forum. And we often will continue if there isn't enough information, either information is missing, or we often will give the applicant an opportunity to request a continuance because they want to change something. They can work with staff on that, but deliberative sessions are very, very infrequently used. They are used, but it's primarily, I would say, when it's a very contentious and potentially argumentative situation.
Yeah, and I mean, you can always, deliberate or talk, not in deliberative session before you close the hearing. So you can have conversations before you close the hearing and enter.
So there was mention of consent agenda.
Mm-hmm.
If something is on consent, how would members of the public be able to hear about, or give input on something?
I have my answer, but I'm going to defer to staff to answer
Okay.
Well, let me take
Yeah.
a swing at it. At least within the planning commission, when we do a consent agenda, within the public comment section, we open that up for questions from even the planning commissioners about anything to do with the consent agenda items. That's members of the public, members of staff, and the planning commission. We use that public forum to have a discussion on the consent agenda, so that when we get to the consent agenda item, we'll know that we can either move on it or we have to take it off from consent agenda.
Usually right after the public
Okay.
comment.
I'm-
It's when we do the consent agenda.
I've sat on a planning commission and the ZBA. I did attend a meeting where there was an application on the consent agenda. It wasn't clear to me that that's the case. So I'm curious whether members of the public also have that confusion around, like, the time to comment on that consent agenda item is during public to be heard.
Well, there's a member of the public who's attended so I would defer to if you want to take that comment from her, or I can swing it.
I'm fine. I'm just giving some feedback
Yeah,
that sometimes that's not always clear.
Explaining what the time to speak is for the people. You have to do that if you're going to comment on something like that. But when it's happening, when the consent agenda is happening, very, very the beginning.
Okay, I guess I had a different experience than that.
Yeah, and that's actually written into their operating procedures. Your operating procedure specifically says if a consent agenda item is to be brought up, it should be mentioned during public to be heard, so that it can be brought into the business. In your
Yep.
And all abutting landowners get notice that is on the consent agenda. So just like any other application, we do notify everybody that's required.
Just curious, is your consent agenda just like minor applications, or what's the
Yeah. So it would be like a small boundary adjustment.
Yeah.
It's when there might not be clarity, or when there might be, for example, as in an earlier situation, when there was work to be done on a public ballpark facility within a public field. That drove the whole consent agenda item, because it was not brought to the commission, yet there were members of the public and even the commissioners who thought that it should have been elevated in its level of review. So it was brought in. That sort of was the trigger for future developments like that, which are not 100% clear. Either the zoning administrator has a question, or other staff might have a question about it as well. So it's another layer. We don't use it as often as we did for a while. We're not seeing consent agenda items come in, which is good, because it's confusing for the commissioners as well if they have questions.
Mm-hmm.
And what do we do when we feel it rises to the level of questions and we might need to change the staff report? Then we have to pull it off from consent.
Yeah.
And then have we met the requirements for a warning? And if not, do we need to advance? We need to continue it to a later date.
Yeah.
That's
So
what you do. You do continue it to a later date.
Because it's we don't want to have that level of if it's not clear, it comes off consent agenda and it becomes a future review.
Yeah, interesting approach. I don't think it's wrong anyway. Yeah.
I'm sorry, I just had to ask a question about something that I thought I had heard. But did you say that sometimes when there's comments from something about the consent agenda, you move it to a business item after the agenda is approved?
It would be moved to be removed from the consent agenda. So if we have 2 or 3 consent agenda items,
Just remove it to future business?
it would become an application, and it would be continued so that it can meet requirements for warning and staff reports. Because consent agenda items don't generally have as complex a staff report as a regular application would.
And they're not meant to be edited
Right.
during time of, it's a decision that's been prepared for the planning commission. Supposed to go.
The simple point is, if there are questions either from the audience or members of the public or commissioners or staff that require a further modification to what we already have in front of us, it comes off from the consent agenda.
It's just removed. It's not brought to business that meeting.
It is addressed because it is on the agenda, but it's continued at that point. And I would have to pull out the operating procedures to see what it is, but we don't.
You wouldn't make a decision that night on that.
No,
Okay,
because
that was the only thing I was curious about when I had heard that, because you can't, obviously but you can't move that to business and act on business from something that's in the consent without after approving the agenda. Would be my comment, because that's
I would say that our agenda is we modify the agenda during the meeting if we need to for the flow, not adding and subtracting items. But that consent agenda item is on the agenda. All the context is there. But we don't act on it. If it can't be moved as a consent agenda item,
then
it's a continued item for a future date.
Okay. Just want to have you add in those couple words, because the way it sounded the first time it was moved to business, and there might have been confusion there.
And again, we'd have to pull. I don't have the procedures memorized, so we'd have to look and see what the context is. But I believe there's some. I don't know if it's called out that much or not.
But if nobody has any questions, though, it could be approved as part of consent, and then it would be
Correct.
without any discussion.
Correct. And that's basically it. During the public comment. Again, it's during the public comment because it's a consent agenda. If during the public comment there is no questions, when we go to the consent agenda on the agenda, we take a motion to either move. If there's a number of them, we may move them separately, but we would move the consent agenda for approval.
Okay.
It's an imperfect tool, but
No, it's interesting. Yeah, it's an imperfect tool, but I think doing it right, given the way that you're doing it, and as long as you're clear, there's small things like PLA is like fine. Anything else on flow?
So this number 6 here has a party/public.
Yeah.
What's the difference there?
If it's parties, if your DRB is making a decision on who is interested party or not, or it's just general public, DRB is not going to make a decision on whether or not someone is party at DRB.
I'm not sure I followed that.
You can let everyone talk.
Yep.
And not actually establish on a person by person basis whether or not someone's an interested party.
Okay.
That's the public part.
Okay.
Or a DRB could.
Okay. So if someone does speak as a member of the public, the environmental court later could determine whether or not that individual was an interested party and whether or not their testimony is admissible.
Correct.
Whether they're
Or
concerned,
if they have appeal right.
or whether they have appeal rights or whatever it is. Okay.
Yeah.
Okay. Okay. That's the. Thank you.
Any other questions on flow? Sure.
So we're not going to public questions yet. So we'll. Okay.
You can come back.
Okay, sorry.
guess this is it.
Yeah. We can
Let's go to
wrap up
public.
now.
It's the opening of quasi judicial hearing.
Opening quasi-judicial.
You want me to try to share my screen?
Sure,
Hold on.
you have.
Slide 33.
It was playing. Yeah.
The opening of the hearing itself, Chair is going to review the order of events like we just reviewed on the last slide. Remind folks the importance of order. Sure, folks have copies of the rules of procedure and code of ethics that we've already talked about. If you want, you can review that definition of interested parties. Administer an oath. It sounds like you guys administer the oath up top. Everything that's okay too. And the request board members disclose any conflicts of interest or ex parte communication that they've engaged in. Right up top. Any questions there?
There's one comment on the rules of procedure and ethics policies. Statute gives the planning commission the authority to generate their own rules and ethics policy. So a select board conflict of interest policy does not necessarily apply to planning commission. Because they have, by statute, the right to establish their own.
Talk to your town attorney. But statute says they shall establish.
Yep.
And so they should affirmatively make a decision. So I'm with you, Andy.
Mm-hmm.
I think.
Because I'm saying this out loud because people have asked.
Got it.
Don't they have to follow your conflict of interest policy? Say no, they have their own.
They have to adopt one. That's what statute.
They may choose to adopt the select boards also, but
Correct.
they may also choose to do something else, and the select board can't tell them which one to achieve.
Correct. Shall adopt. Other questions? Okay. Good board chairs are difficult to come by. And a good board chair shouldn't do a lot of talking. Should state questions. They should move the business along. Ask for discussion, typically without asserting their own opinions. They can if needed. But they should definitely, and most of the time, trying to bring the board a resolution, focusing motions on it, asking questions, asking if we have enough evidence, asking if we need more evidence on X, asking if we're ready to enter and deliver a session. Really, the organizer of the board should be. This isn't for us. It's just for all the small towns. Any questions on the role of board chair? Everyone else, listen to the testimony, ask questions. Have your regulations there at the ready so you can refer to them. Control F, I like to have my computer in front of me so I can control F for terms. Try to find terms in the regulations. No other way to be in planning and zoning without using control F. You're supposed to make sure that your decisions are based on evidence. Don't prejudge a matter. Or talk about the case in public. Any questions on board rules? Slide. Talked about deliberative session a bit already. It's exempt from open meeting law. Don't have to keep minutes. Public or private, whatever you want. Don't have to reveal how you voted. 45 days. After you enter it, 45 days to issue the decision. If there isn't a written decision after 45 days, deemed approved. Typically, an applicant has to go to the e-court to get something deemed approved. Happened by magic. What else should I say? Technically, you're in deliberative session until the written decision is signed. Remain aware of that. So, I mean, you can already vote, but technically, you are still in deliberative session until there is a signed written decision.
So that gives us. There's been it's an opportunity for discussion a little bit because we've had confusion on number one. Do we have to close the public hearing? We did. Should we? Can we take minutes? This looks like it's an optional thing, and we've.
If you're in private deliberative session, you do not have to take minutes. If you're in public, I would say that you would have.
What's the difference between a public? Public is when we're not entertaining motions for.
Public and private is when you literally. Public is when there's public in the room, and private
Okay.
is when private is, or when the public is on the roof.
Okay.
Just the
So that would be our normal once we've closed the public hearing and we deliberate. That's a public deliberative session, but we're not entering into we're not calling it a deliberative session per se. We are deliberating. Private deliberative session. We've had a couple things. Number one, we've been operating under the assumption that we cannot take minutes.
correct.
So that's okay. That's the difference there. Private, no minutes.
Correct.
Okay, I'm good with that then. We'll stop there.
And the one thing I'd say too is that when ideally, when you're making the motion to go into deliberative session, you're saying like, we're going to go to deliberative session and we're going to bring staff. We're going to bring X people with us too. And I just think that's important just so there's transparency about who's actually in the room.
It's a lot easier not to go into a private deliberative session. Quite frank, it's
It just, Don't if you don't have to, but don't be scared to if you have to. That's kind of the general rule.
That doesn't have to be on the agenda.
Deliberative session should be on the agenda as a separate item.
Right.
Correct.
So if it's not on the agenda, you cannot go into deliberative session.
I would say that. Yeah.
Okay.
It has to be a separate agenda item, just like you guys would have like.
Yeah,
exec
for
session.
executive session. Yeah.
Same thing.
Okay.
Yep.
I was just a little confused with the wording there. It says no requirements for notice. Just wanted to make sure that people understood that they still have to have it on the agenda if they plan to have the possibility to go into deliberative session.
Good catch. So let's talk about that. So not an attorney, but right. So when there may be a condition, and I wouldn't advise doing this like as a best practice, but there might be a condition where you have a DRB meeting. So you have a DRB agenda, you have your applications, and you have deliberative session as a separate agenda item. And for whatever reason, let's say the DRB doesn't finish deliberations then. The DRB needs to meet again to continue deliberation, maybe the next day. And so in that circumstance, because it's not a public meeting, it's not a meeting that's taking place and it remains in private, and this is a circumstance of private deliberative session. In that circumstance, the DRB could convene again, not hold a meeting, and continue deliberations in private, let's say the next day or the next week, without giving notice to the public.
Okay.
That could happen. Again, I don't think it's a good idea. I think you should do an agenda. But my understanding is that they could thread that needle if they needed to. Does that make sense?
Yeah, I was just focusing more on for the public if they're listening to us.
Yeah.
That if there's to be a deliberative session, it needs to be on the agenda before the meeting is opened.
Correct.
That's an interesting twist, which would mean we would need to start putting a placeholder for deliberative session on our agenda routinely, because we've used it routinely as a resultant of public deliberation, and it usually has been a motion by a board member to go into deliberative session.
I would put it on your agenda, just like Selectboard puts exec session, just in case.
So noted.
Yeah, because I don't know. Like, I read the Robert's Rule book a couple times before I joined the Selectboard, but I don't know exactly how it's worded. But when I was just reading through this presentation, it sparked my mind that for the Selectboard, it's absolutely 100% mandatory to
get on the agenda.
Get it on the agenda if you even plan to go into executive session.
Yep.
I didn't know if deliberative session, and like I said, it could be wording difference. I'm definitely not an attorney. So, but it just sparked in my mind when I was reading that.
Put it on there.
So,
yeah, but it hasn't been to date. It hasn't been a planned event, so it would make sense to put a placeholder on there. We don't go into executive session hardly ever.
And that's always on the agenda.
So,
you're right. Wrap up there. Or do you want to get back?
I was just trying to help the camera and just letting people stare at the screen.
Off stage.
No. I'm trying to help the production value.
Conflict of interest, they're hard to avoid sometimes, especially in a really small town Vermont. But your code of ethics should talk about what conflicts of interest are. Financial interests are pretty easy to understand. Personal interests, again, common in small towns where you're gonna have cousins, one on the DRB and one submitting an application to build something, and that happens, and probably recuse yourself because of personal interest. Known bias or prejudice, again, really small town Vermont. You got someone on the board and someone they went to school with that everyone knows they've hated each other for 12 years. That's a known bias. You should probably recuse yourself. Ex parte communication is really about discussing the facts of the case outside of the hearing itself. Not technically legal. You shouldn't do it because of the last little quote there, which is trust is really hard to come by, and takes a second to destroy it, and so and it takes forever to build it. So try not to talk about facts of the case or case really at all outside. Any questions on conflict of interest? Okay, moving on. Adopt rules of procedure, code of ethics. Recuse oneself liberally. Use alternates. Definitely use alternates. With alternates too, like some DRBs are like always alternates always come. Allow alternates to ask questions just like a normal member. They just don't vote. Some DRBs only like to have the 5 DRB members up there. They're the only ones that can ask questions. It's up to you. Just having your rules and procedures about how you want the alternates to interact with hearings.
So something that we recently just discovered is that because our model now with the planning commission and the ZBA, the planning commission can have an alternate because they're doing that.
Because of that already.
Yes, but once we switch over to the PC DRB model, the PC can.
Correct. Any other questions? I think this is it. Maybe. Oh, there's one more slide. Due process. Just all about public notice. All about allowing people to be heard, about having an orderly proceeding, properly managing evidence, and conflicts of interest. Making sure you're following your own rules and as a part of the process. Process can be appealed too. That's messy because then court just remands it back to you and you got to do it over again. And that's a waste of everyone's time. I've already said it. Yeah, info. A lot of really great stuff there. Need an example rules of procedure or code of ethics. It's on VPIC, also VLCT as a really good model. And for staff planning on bylaw adoption tool up there, make sure you follow the right process. I think that is it.
Any board member questions, I guess, from either board?
I just had one more little clarification. So Essex doesn't have alternates for the planning commission?
We do have one.
We have one.
We do have.
And in practice, when the alternate was here, I would have them at the table regardless of whether or not they were a voting member that night.
It just seems like a good thing.
Well, it makes sense if they want to sit in on a call on an application later to have knowledge of what's been going on. And technically, they are a planning commissioner, just a non-voting one, so their input is also valuable.
Thank you.
So
Ethan's got to have something. Ethan's got to have something. He can't be done yet.
I have a question, but it's gonna wait for after. 'Cause I have
So I do have a question. We have multiple state highways that go through our town, which we don't have a lot of jurisdiction over.
Mm-hmm.
And you're recommending that we look at this planning for great neighborhoods.
Mm-hmm.
In some situations, those state highways make it difficult to do that.
Just a couple things. Right now, we're doing a pilot study with the town of Williston. That pilot study is looking at the cost-benefit ratio of Class 1 town highways. And it's building off a white paper that was written by V-Trans and a consultant a few years ago. And we're trying to kind of take a look at the numbers again in terms of what the true cost is of maintaining a Class 1 town highway for V-Trans. And looking at how we can provide more of a carrot to municipalities to entice them to take over those highways, either in terms of control over what happens on the roads themselves or process things related to like improvements to the road by V-Trans before the town takes them over, or just in terms of like money and talking about or looking at the formula used in terms of town highway aid for Class 1 town highways. So we've got like a draft report right now. PHP is working on it with the town of Wilson. We're managing it and paying for it. So I can share that with you folks when that's done.
That talks about taking them over.
Talks about taking them over.
You can't do things that would impede traffic flow. imagine.
If you
once
don't take
do
them
that.
over.
Hmm?
If you do take them over, you got a lot more. I mean, if you take them over, I mean, you've got control and design. Not total control. But in the white
Right.
paper, it talks, there's a nice little chart in the white paper that talks about, if you do take control, here are the things that you do and that you're responsible for. And if you don't have control, here's the things V-Trans does. And the thing, if you take control of a class 1 town highway, you're in control of most things. The only thing V-Trans will really do for you is like a resurface, I think, or sorry, they're in charge of reconstruction still, maybe resurfacing every couple of years, and they'll do the striping for you. But everything else, I think you're pretty much in control of. You'd have to design the road, if you're doing like bump outs or like that. Still, you'd have to, I think, get V-Trans approval. Like meet some sort of basic standard that may have buried in some manual somewhere. But you could do it, unlike when they're highway.
So if we're asked to do things that would reduce the number of trucks that go on a specific road, I think there might be some objection from others,
Asked by whom to reduce the number of trucks that go on our.
by residents who live in said neighborhoods that are affected by
I mean,
highways.
you can be asked by residents to reduce the volume on certain roads, but you don't have control over who drives on
Right.
certain roads.
Right.
You can influence who wants to drive on those roads through
That making
design,
it difficult to drive on
Yeah.
that road.
but
Yeah.
but you don't have control besides like your load limits. But on
No.
the state highway, I mean, they're going to be built
Yep.
all the way.
That explains the roundabouts.
Well, yeah, I mean, not all of them. A lot of them are state.
That's why they're really
Yeah.
small.
A lot of them are state. The smaller ones are usually municipal.
Yeah.
But it's, I mean, it's, I don't know. V-Trans, wants to give you the road. They want to figure out what the price is. Really. And, the municipalities that have them, I mean, some love it and some hate it. It depends on how much they value control. St. Albans City loves it because they've got full control right downtown. But you talk to Enosburg Falls, and they're like, yeah, we have full control, but it costs us $1 to maintain that segment of road, and the formula doesn't give us enough in terms of so it depends on how much you value.
Did Milton take over part of the Route 7 corridor? Or they haven't. They just did the
We're doing a project
sidewalk.
right now. That you do sidewalks,
Yeah.
and that was a big change.
The
10
trees,
years ago,
yeah.
we
Yeah,
used to
yeah.
have sidewalks.
I grew up in Milton, so I was a
Okay.
little offended earlier, but I'm okay.
I'm working on a downtown project in Milton right now. Got a great relationship with Tom.
My dad's
No,
been there
it-
for 32 years.
But
Right?
Milton, but that's it's the same issue in Milton. I talked to Don last week, and he's like, "We're gonna do this downtown project," and he's like, "Well, we're never gonna have the downtown face Route 7 because we have no control over it, and cost benefit wise, it's never gonna make any sense. We're gonna have it downtown. We got to do it on a local road. We know we have control over what that road looks like. We know we have control over sidewalk width. So, yeah, in Chittenden County, I think it's Winooski, it's Burlington, South Burlington on part of 2, not on 7.
Essex Junction?
City does.
Yeah.
Essex Junction does. Colchester on 127. I think that's it. I think everywhere else it's still state.
So go away from roads for a minute if you're good.
Yeah, good.
So we talked. You mentioned a couple things that the town plan is an enabler for language for regulations and so forth. And not to be afraid of if you need to do a lot of waivers, then not to be afraid of changing zoning and so forth. And that starts giving me like goosebumps. Not good goosebumps. But it takes so long to get a town plan update done that it's always a challenge to do the enabling language. So we've actually started this year better than years past, especially since we're mostly electronic distribution of stuff, is to try to do smaller bites of regulations and get them to the select board to get them implemented. But at the same time, changing a zoning map has all those intended consequences are a lot more scary. So when we start talking about trying to accommodate I can say tiny houses because it's been a hot topic of late. We don't want to have somebody putting a tiny house in a quarter acre lot as a second item in a quarter acre lot when it's just going to be a mess for the neighbors immediately adjacent. So I mean, there's all this stuff going on, and we can't. I say you say we can't. It's a big step. That first step is a big step to start thinking about changing the overall zoning map, and to start thinking about making smaller areas for zones. All of a sudden, the specter of spot zoning looms, and it becomes the big ugly. So it's daunting to look at the overall. But that's the way a planner's for.
It's yeah, right. It's up to your staff's for. I think it's daunting, but you know the map's the hardest part. You know, I think there's plenty of tinkering you can do in the language, have a meaningful impact, especially because you can create district standards. You don't have to change the map. So
Well, I remember how long it took us to do ETC next.
yeah,
I mean, that was not a quick, easy process. I mean,
planning takes time.
yeah.
And I think, you know, the approach you took with ETC next to concentrating on specific geographic areas, so just like taking the whole map, whole hog, mark, you know, kind of doing sub-area plans. Look at, like, what's Burlington? And talk about Burlington anywhere else besides Burlington. But, you know, Burlington's doing you know, BTV South End, BTV Waterfront, BTV New North End. They're kind of doing these neighborhood-based plans, and that's really where they're getting down nitty-gritty of how they want to change their zoning, really. Non-regulatory things, to looking at transportation, looking at streets and stuff. It's not the comp plan itself. They're going down to the neighborhood level and talking to people in those neighborhoods, not just city. So I think ETC Next is kind of the right approach you should take, and maybe bring that to other Susie Wilson area, you know, or that sort.
Two other things real quick. Number one, I like what you just said about planning takes time, and I think, you know, your point of calling stuff out. This is not a quick process. I mean, I've been doing this for a while, and it is not a quick cycle. Town plan updates are not something we're just going to knock off in a few months. I mean, it's not that quick. And I had another thing, but I lost it, so I'm gonna have to shut up now. I had to, honest.
Well, good board chair is supposed to move the meeting on to the end. So I was just going to ask if there's any other board questions, either for Taylor or for the other board, either side.
I just
Kendall, go
have
ahead.
one. Are there any communities that basically update their town plan yearly so that they don't have to wait and go through a whole process of the whole?
There's I can't tell you off the top of my head. I know some communities will like update a chapter each year
Yeah, that's
and kind of prep and then adopt it all together. I know some RPCs do that too. You can do that. I don't love that approach just because there's so much data. And maybe if you did that, you know, you kind of do like your data appendix last, you know, and kind of update the text at the end or something. But you could. I'd say do it whole hog every 8 years. Wait as long as you can.
Well, everything changes too. So I mean, if you start it and you're doing it, you know, one chapter a year, by the time you get to the end of that 8-year cycle, what you did in the first chapter is essentially out of date and out of compliance with state.
And then you got 7 new members in the PC, and you know, yeah.
makes sense.
All right, so let's go to public comment. And so I think we need to allow access to the microphone here.
Yes, please.
So if you can come up, introduce yourself for the record, and ask your question. We'll play tag team on the mic.
The question was just, he talked about the book on, I think it was a book or pamphlet, I don't know what it was, Planning Better Neighborhood.
Yep.
Where do you get it?
I can provide a link to Catherine, get it to you, but it's on EC website.
Yeah, I can get you that link.
Okay.
And it seems like maybe we could request a hard copies as well. I know
Yeah,
we
I would
initially when
prefer
it
to
first
have
came out, we got a bunch, but
Yeah, I would prefer.
They may still exist.
they
I'm
might not.
Sure.
Yeah,
It's been a couple years.
I'll send you that link. Yeah.
Okay, thank you. Any other public comment or questions?
Looks like we've got one online.
Lorraine, go ahead.
Hi, thank you, Chair, for taking my question. And thank you for presenting this to us. There's a very complex a set of rules and regs, and it's just very complex. So it's good to hear from a county level person. A couple questions. One on like a code of ethics. So, for example, if we had someone that was on the planning commission that was good buddies with someone who was an applicant, would that be a recommended time to recuse oneself?
Yeah, I mean, again, it should be outlined specifically in your rules of procedure code of ethics. But yeah, that to me would be a personal interest.
Also, like in the zoning regs, for example, we have one sticky wicket of a zoning district, which is our RPDI, which I'm not sure if you're familiar with that or not. The resource preservation. So we have a light industrial district that's called the Resource Preservation District - Industrial. I commonly, and I get frustrated with this, I commonly hear people keep calling it industrial. It is industrial with conditions. So when I hear it referred to as industrial, it frustrates me as a resident here because it greatly impacts a lot of us because it's surrounded by residentials. And we've been putting in distribution warehouses. So it's increased the truck traffic between the exit and to the circ. And it's on both ends. There's parallel roads. There's 117, there's 15. And that it can go down either way, but it's trying to get to the circ generally or trying to get to North Williston Road, either one of those. That's the, that was the identified truck route at the county level. So on the Resource Preservation District Industrial, the core drive of that district is to preserve resources. And part of that was contiguous forest lands, which are upland. It's on a hill. It's got a lot of sand. The sand runs, there's tributaries from there that run directly into the Winooski right next to 117. So its primary focus, written right into the town plan, is that it's to preserve resources. And so many of us as residents are very concerned about the consistent waiving of the 50-foot buffers, because some of those 50-foot buffers, in our view, was also meant for contiguous forestry for the animals, we had a lot of deer in there, we had a lot of fox in there, a lot of stuff like that. So when you waive a lot, that sounds like it's a red flag to change the regs one way or the other, from what I'm hearing you guys say tonight. Yes, like if you keep waiving something, then it's time to re-examine the regulations for that district.
My advice would be if you're consistently waiving a rule, that you should probably get rid of them.
Right, or change what can change the uses.
Or I mean, you can also change the buffer, yeah, but I mean, I guess
not even
regardless of the specific circumstances.
Yeah, not just the buffers though. I'm saying if it doesn't work, if the goal of that specific district is to preserve resources, so what I'm saying is, then at that point, you would either change the reg and get rid of the buffers, or you might consider changing what that was zoned for.
So Lorraine, I think to address a little bit of that, one of the reasons that the 50-foot buffer is waived, or that's waived generally with conditions that they have to be replanted.
I understand that, Andy, and I've watched a number of these meetings, and part of the issue with that is the primary focus is contiguous forest, and we're taking down those buffers, and that's part of what the animals were using. So when you drive down Sand Hill, you can see the mountains. There's no place that the animals are going to go.
So Lorraine, what's happened there, is a choice was made at some point in the past not to do forest management of that 200-foot buffer. So yes, the trees are tall enough, so it's like a buffer in the sky, because all the foliage of those trees is significantly higher than it used to be. And so it's my understanding that there is some active discussion about whether to start allowing forest management in those areas to fill in the gaps that you're talking about.
So, and some of it reforests as well on its own, Andy. It kind of happens. But what's happening is in between the buildings, there were buffers, tree buffers that have been waived, and there were also on the road on Corporate Drive. Those were all buffered too, and so those are gone.
Lorraine, may I chime in a moment?
Sure.
The 200-foot buffer, which is where the forest management practice is actually, there is a forest management practice, or used to be, prior to the town and the landowner coming into discussions. So since the RPDI was originally created, there was a forestry management plan by that landowner for the 250-foot buffer, and that was the only purpose. That was the only intrusion into that buffer that was allowed. And that forestry management plan was up to that landowner, and it could have been clear cutting, it could have been no cutting, but it had to have a management plan for that 200-foot buffer. The only intrusion into that's allowed today is an easement for utilities, and that's it. There's no building in it. There's no we don't planting trees. We're not. It's not part of any application that work is done in that 200-foot buffer. There is a 50-foot buffer along Corporate Drive and what's the other one? Thompson Drive, internal buffer that's is pretty much. The waiver has been in place and has been maintained because it has allowed us control over that space to remove scrub, because that 50-foot buffer is not a wildlife corridor. It generally has been populated with scrub trees and or brush. So that 50-foot buffer has been consistently utilized for stormwater management without physical structures being created. The 100-foot buffer in between the properties, that's a little bit of a different story. There have been requests for waivers there, but that 100-foot buffer has still been maintained. And a buffer is not necessarily a visual barrier. A buffer is a space between the development. In some cases, there's visual and or sound barriers. In some cases, it's just space. So it is the industrial use of that area has been a prime economic tool in Essex's toolbox since it was created. What has changed in the last 10 years is that it went from being an area that was 100% exclusively under the control of the Planning Commission. There was no rules or regulations that couldn't be waived. There was no use that couldn't be allowed. It was 100% Planning Commission discretion, to an area that now has a dedicated town portion that's owned by the town for recreation use, access, and an area that is now able to be marketed as an industrial space. So it has been a very interesting history in that particular parcel, and has been ever since I've been here on the Planning Commission. And we're at the point now where we actually have probably more control as a town than we've ever had on it before. So I think it's in this case, the waiver has been used as a tool to manage the infrastructure and to maintain a consistency of presentation. So whether it can be a waiver and then needs to be put into a regulation, but it has allowed us to specify what that presentation looks like. That's probably more words than I've spoken all day today.
The other issue with the 50-foot buffer is that it's all the trees there are quite mature for the species that it is. So the foliage is up high, and when you clear past the 50-foot buffer in the lot to do the development, you now have this very weak, it's very vulnerable to wind and the elements. And so what happens is these very tall trees start falling down. What makes more sense is to probably get rid of the trees that are not going to last much longer and are a hazard, and replant it so it can be, possibly a habitat or a wildlife corridor, and be more useful and possibly more appealing than just looking at trunks through at a new development or a new building or a new storage area or whatever it is. I just want to make that point about why we've waived that space.
Can I talk?
Go ahead, Lorraine, do you have?
Yeah, so the trees, yes, they do get weaker, but there are a number of trees. If you look at where like Essex Free Library is, there is a row of old growth pines right between there and the building that's right next to it. Depends on how you cut buffers and how you end up developing the land. There are trees all over Essex that are in succession that are just one line of big pines that aren't falling on people's cars. And also the trees function for birds too. It's not just for ground animals. And there's ways to add to trees instead of cutting them down that you can do the lower growth as well. And I disagree that that is just for the inner core too, in terms of how I interpret the RPDI regs and what we need, as well as the fact that those are upland, and that specifically the RPDI specifically talks about the upland forest, and that was a big part of the upland forest. So I disagree, and I think personally that the parking lot should not be pushed out to the edges of the ends, and the fact that we now have a noise ordinance, there should be sound buffers automatically added into there, because a lot of people are suffering from this, and specifically in the ETC next plan. It was in that we finished in 2020, put into paper, not in 2021, but 2020. It said that the goal, which included Saxon Hill, was to reduce traffic going down 15. And what we've done is increased not only just regular traffic, but we've increased a tremendous amount of diesel truck traffic. And so when I look at the jobs that go into that section and the economic developments, and I see at Blodgett and I see at the other clothing that they're desperate for help, I'm not sure that this is working right in terms of the cost to the rest of our residents here. I would have much rather seen that be a resident, but that's something just want to throw out there in terms of the how it's interpreted by a planning commission, despite residents saying for years now that this is a problem. So I don't know where we can go from here, because I just keep seeing more of these go in. I personally think it's against the town plan. But anyway, I just wanted to speak to that. So I appreciate your time. And Dusty, thank you for your viewpoint. I always appreciate that as well. Thanks.
Thanks, Lorraine. Any other comments or questions from the public?
Catherine has some evaluations.
All right.
So if you guys can fill those out, that would be much appreciated. ECCD makes us do this, so sorry. I don't know, Catherine, if you can scan them maybe, or get them to me tomorrow or this week or next week. That's fine. But just want to reiterate before I go. We're here to serve Selectboard and the Planning Commission and the DRB. So municipalities, you guys have questions, you can be a technical resource.
Just to
as a member municipality, 12 hours ish of free technical assistance per year, guaranteed it like immediately, the next day, but we can provide that. Larger projects, just remember that you've got to come through our UPWP process, our Unified Works Program. We solicit applications in November each year. And so when you start going to budget season, in September, October, think about what projects you may want to come to us for. Make sure you're allocating enough money in there for match, or we'll pay us fee for service, or whatever. Thanks so much for having me.
the Metropolitan Transportation Plan is out for review and open for public comment until May
The
17th.
Metropolitan Transportation Plan is out for public review right now. It's on our website. There will be a public hearing at our board meeting on May 17th. So if you'd like to review, provide some public comment, that'd be great. We recently adopted our comprehensive economic development strategy, which we did in coordination with Addison County, Central Vermont, and Rutland County. That adoption of the document allows municipalities in the county to apply for funds from the Economic Development Administration of the U.S. Department of Commerce. They have a public works program. They have a technical program that they generally fund projects that are infrastructure related or related to job growth. So for industrial park or wherever else, please keep EDA in mind. And we're working on the ECOS plan, the regional plan right now. EGRs have done it every 5 years, not every 8 years, because the MTP and the SEDS are only valid for 5 years. We're doing it year 6 this time because of some staffing changes last year. So we're a year late, but keep an eye out for that. That'll go out to public hearing, or probably around Christmas time, January.
Thanks so much, Taylor.
Hey, thanks so much, guys. Yeah, nice to
Thank
meet you.
you.
Thank you.
So any questions that the select board has for the planning commission, as long as we're here in a joint meeting?
I have a question for Dusty. You made, or maybe it was Shoe, that a buffer is just space. I thought a buffer, when you talk about a buffer, is something that keeps, like, you away from something.
So that you hit a really good point.
Sorry.
Because what is a
Depends on the
buffer?
intent.
There's no set definition of it. I mean, because it could be a wall, it could be nothing. You're right, it is a separation, which is space.
Okay.
What you do with that buffer and what that buffer is intended for is quite variable. So is it intended to hide something from view? So do you need like at the hospital, they have on the back side of the hospital, they've got a 20-foot solid wall
yeah.
to buffer sound from the adjacent neighborhood, the downhill neighborhood? Or are we looking to buffer sight? Are we looking to buffer sound? Are we looking to have a wildlife corridor? A separation like that. It isn't all one. There isn't one single definition at this stage, and I would be very scared of a single definition. We just had an application in recently that the neighboring residential community and the applicant came to an agreement of there was a natural buffer of 30 feet, 50 feet, 30 feet, whatever, that was forested, not heavily, but they also put in, the applicant agreed to put in a stockade fence to provide some sound and light barrier to prevent light spillage from car headlights. So what is the buffer on that one? The separation is the space,
Right.
and what do you do with it? So you asked a good question, but I don't see one that has a clear answer, John.
It's because most of the complaints we get are noise. And it's because they took down the trees and now it's noisy. I would.
But to like the point John said, I mean, the RPDI is a good example of that because I mean that was a plantation,
Right, I
and the
remember.
trees are all very mature, and there isn't a lot of understory. Is that the right term?
Story, yeah.
There's not a lot of understory to provide a buffer.
Right.
So do you put a fence up? Do you plant more trees? What is the need? So we start with the space.
Okay.
You all set? Because Ethan's chomping at
Yeah,
the
I
bit.
know he is. Go ahead.
I have something helpful.
We doing.
I was just gonna say to Shu about the trees, because I agree with you. Take a group of trees that all grew together, and then you move the trees around it. That tree does not have the same strength as a tree that was planted individually, whether it was in a row or not, and had its whole life to develop in this environment. But my question is, or possible, I don't even know if it's a suggestion or not, but I know that this is part of the process, but with the trails in Conservation and Trails Committee, did you guys, they see a lot of these things with the buffers and stuff like that. Did you have any sort of recommendation from the town forester that just solidified your interpretation of those trees?
Not that I can specifically recall, but
That would be,
We do.
we did talk to him, and that was
Yeah.
one of the things that we were told was, yeah, if you're cutting trees on either side of this buffer, you are basically isolating those trees. Yeah, they are mature forests, but they were growing in an environment that they don't have anymore. Do I like the whole idea of cutting those trees down? I do not. Right? But what makes the most sense is to either thin them and then plant so that they can get sunlight and grow, so you can fill it in, or probably the easiest thing is to utilize that space to deal with things like stormwater and that sort of thing, replant it, then what's there will grow up and fill in. Sure, I mean, most things don't look all that great after 2 or 5 years, but give it 20, it'll look great. So a lot of these things with planning, you can really be focused on what you're looking at today, but what you really want to be talking about is what's happening in 25 or 100 years. That's what's really important with all this stuff. And yeah, there's, it's like logging. Logging is ugly. Go back 5 or 6 years later, it's totally different. So And I don't believe in clear cutting or any of those things. I don't want to get my personal opinion too much wrapped into this, but what we've learned is that those buffers, those particular 50-foot buffers along Thompson Drive and along Corporate Drive, they just don't, it's not a good plan to leave those trees there. It just doesn't work. And that's what we were told by a forester. We're trying to adjust. And maybe we do need to change the regulation. No.
But to go on to that as well, we have the town forester who we've consulted, who has recommended more than once to start providing consistency along the roadways.
Yeah.
So we don't have, the applications aren't coming in all at once, right? So we're having one applicant bring in, I want to develop this lot. So they have a plan for their street front. Another applicant, they have their own plan for that street front. So what the forester had recommended was that we start working for consistency. So again, that's where the waivers starts coming into play, is we can start managing the consistency of appearance and presentation, especially on Corporate Drive, less so on Thompson Drive, because that's still more built out. But and Red Cedar,
Red pine.
Red pine.
Yeah.
So Red Pine and Corporate Drive especially, a lot of that build out has used that 50-foot buffer that's adjacent to the road for stormwater management, because doesn't require structural infiltration. It's just there. We don't want parking there. We don't want structures of any kind in there. But what is there for planting oftentimes isn't even trees. A lot of it is just scrub brush, and it detracts from the appearance of the overall area. So it's an interesting balance, and I will say quite frankly that buffers have been a source of discussion anytime they've come up in the last 20 years. Buffers have been open to interpretation by everybody who looks at it. So there isn't necessarily a clear one answer, and if we put one answer in, it's not going to work for every single application and everything that comes in, because somebody is not going to like it, even though it does it may do exactly what we put the regulation in for, and it's not going to work 5 years, 10 years down the road.
Also, to be clear, that just back to the waiver discussion, there's not a waiver for anything but that 50
Right.
buffer, and the planning commission has never waived the 200-foot buffer.
Nope.
100-foot buffer.
We've even gone the opposite of people, somebody who's offered to put a structure in that 200-foot buffer to provide a visual barrier. And it's like, no, that 200-foot buffer is it. No, there's no entry in there.
That counts toward the 60% concern.
Yeah.
Unfortunately, yes.
Yeah, I was just throwing that out there, that it's nice to have somebody to lean on and say, this is a recommendation of.
Yeah. And
Yeah,
it's yes.
I'll be quiet now because I want to go home.
And any
Well,
other?
I have just one more thing.
Go ahead.
I would like to thank Tom Ferlin, as this is his last meeting
Yep,
for his
thank you,
service
Tom.
on the
Yeah,
committee.
yeah.
Agreed. Ditto.
Thank you, Tom.
Thank you,
Thanks,
Tom.
Tom.
I
Thank you. Gonna miss you guys too.
heck with that. That's what they think. Little things.
Tiring, I heard.
Yes.
So does the planning commission have any questions for the select board?
I think, and everybody will go around here, but the future is changing, right? We have change in the advance, and I see we have two members of our zoning board here as well. I guess I think it's two. It would be. I think we don't really know what was broken. So the change in the change in the model isn't the drive for that isn't necessarily clear. So without having a good foundation, it's hard for myself, and I'm not speaking for anybody else. It's hard to know what the real goal is. I mean, even tonight, Taylor was interchangeably using DRB and PC and so forth. So it would be, I think, a really good opportunity now to start having discussions with all of the groups even not even independent of who might be on those future commissions, boards, but to get some ideas of what is the end goal, what's the end design, and I know DRB and PC, but what's the intent? What are we missing in today's model that we're going to get with the new structure? Because if we're not getting anything new, if we're not getting anything improved, why are we doing it? I mean, I'm not pushing against it. It's just we need to have an idea of what we're trying to get to, different than what we're doing today. Again, I'm not talking as an individual, but as a community, we made the choice to make a change. So what are we looking to gain? And also what might we lose? When we go to this model. So it's just I think it's an opportunity for discussion, and I would really like to see if we can find a way to have all three groups, come together a little and have a more active discussion, so maybe we can help participate more actively in the transition. And I'm not speaking for you guys either, but I'm really thinking you have a viewpoint that I personally haven't heard represented in this process. So my request is to engage.
I'd echo what you're saying.
Maybe can you come closer to the microphone?
Yeah, my name is Hubie Norton. I'm on the zoning board, and I'd echo what you're saying is that processes with the zoning board, in my opinion, the zoning board acts more as a quasi-judicial board than the planning commission does. Okay, planning commission is reviewing new stuff. Okay, well, excuse me. Planning commission is creating plans, and when it comes to site plan, sketch plan review, site plans, you're reviewing new stuff. Zoning board is tending to deal with existing stuff that needs some approvals, conditional uses. It requires some judgment. What are the rules? How does it fit? Variances. Okay, his comment, and we've heard this from lawyers before. There's no way you can grant a variance because the rules are so rigid. Well, it was put there to allow for the opportunity for someone to make use of land that was restricted by some encumbrance. That makes sense. Okay, so we're acting in a different manner than the planning commission acts. So now taking some of those duties that were formerly a part of the planning commission, that is sketch plan review, site plan review, and so on. Now combining that with what the zoning board is doing, kind of like a little bit separate things. One of my questions, and I wasn't going to ask him, but anyway, how a future DRB is organized, manage those elements differently, because I would think that when you're deliberating about a sketch plan, you're going to have a different mindset than when you're dealing with a variance, or you're making a judgment. You're really acting more quasi. So I agree with you, is that I think there's a lot of unknown here. I'm a great believer in not reinventing the wheel. There's a lot of places that are using DRBs. You have to learn from their experiences. How are they structured? How do they handle those? Yeah, I agree with you. I think it's a change, and there needs to be more introspection. It's going to happen, all right. But how is it going to be formulated? What are going to be the operating procedures for the DRB? To manage. So I agree with what you're saying, Steve. I think that there's more discussion.
Yeah, so it's my sense from the discussions that we've had is that it's the separation of planning from review, and is it and I think it's not to only a separation of activity, not people. It's totally acceptable to be on both boards if somebody chooses to. So there's no, and in fact there may be a reason to have some cross pollination of folks if they're able to stand up to do that. Because I've heard discussions about you're going to lose understanding of the regulations if you have one group making the regulations and the other group implementing them or making passing judgments on them. And so from that perspective, at least it's my view, we haven't. We'll probably have more discussion about this as well. That it would be helpful to have some folks on participate in both boards. But I think the intent is to allow the planning commission more time to do planning.
Right.
Anything else anybody else wants to add to that? Or why we went forward with this?
It was to allow planning more time, because all the time they're having to spend on the town plan now and other things is taking away from, to give them more time for planning, and DRB would have more time for review and enforcement.
It's interesting to me that they call it DRB, Design Review Board.
Development
Review Board.
Yeah, okay, I'm glad you say okay, because
I keep getting the wrong word. Say the wrong word.
Development Review Board. So it's like
We could have a design review board.
I
know we can.
yeah,
That's a different thing.
But the Development Review Board kind of suggests that it's more slanted towards sketch plan, site plan, than it is towards conditional variance kinds of.
Well,
That's in the title. You can't get hung up on the title. You need to.
Yeah, so the new model would separate the legislative from the quasi judicial. So the DRB would do all of the quasi judicial,
right.
and the planning commission would be
understood.
legislative.
It's just, like I say, what's in the title, but
it's
a little bit. Thinks more about development, okay, not about making use of what you already have in order to either get a conditional use or a variance. So, like I say, it's a little bit quibbling about.
And I do think, this was a decision of the community, right? Everybody voted on it. This is the direction they wanted to take. I do think that this is a worthwhile discussion, and I would support having a meeting where this is an actual agenda item and the public knows we're talking about it so they can come and weigh in, since ultimately they made that decision by casting their ballots.
Yeah, if you did a survey of the populace, what is it? What's the function of the planning commission? What is the select board? There is a lot of.
What is the zoning board?
Yeah. There's not. I have questions every day about somebody say, what does the zoning board do? Why do they create those? We don't create nothing. Okay, so there's really a misunderstanding about local government. So to say that the public voted and agreed to development review board is like, they check they rely on the people they've elected to come up with a plan. So on.
At this point, I think that the discussion or the whether or not it's going to happen is no longer an issue. Right now, we're at the point of how to do this, and the devil is going to be in the details. Right. So to make this good, make this right, now start the offer. I think that I'm making is to tap into what the resources that you've already got, not just other neighborhoods, but the people that are here, to find out what needs to be done. What do you guys do? What do we do? We're wearing two hats all the time. There's value in that. Is there overhead? Maybe, but at this point, it really is. It's got to start transitioning to a how, not a what, but a how, and make this work.
And so May 8th, the select board is going to sit down. We're going to have our strategic planning meeting, and knowing that this is in front of us, this will be one of the things that, of course, we ask for. Staff will recommend a way that we can all interact and get from where we are today to where we.
Yep.
But the timetable is July of 2024. Is that it?
It's
January
1 of 2025.
January 2025. Okay, so there's time.
Happy New Year.
And so this the charter change that puts that in place has not been approved by the legislature yet. It may have been introduced this week. I'm not sure if it went. I think a draft went to legislative council. And so it may not get approved this year. And so we'll see if and when it gets approved. It may challenge that date. If so.
There's expectation that that date might be challenged.
Well, I don't know. There could be, I don't know if we'll be asked to testify. If they approve it this year, then okay, we probably have enough time. If it doesn't get approved until next year, we suddenly have a 6-month window, right, to do it in. Because we don't know for sure that it's going to be. I can't see any reason why they wouldn't approve it. But if they don't approve it this year, there may be an argument to say that date's too aggressive. I don't know.
At the end of the day, we still need to plan as though it's going to
Yes.
happen so
Yes.
that we're not behind the.
Yes.
Yeah.
We don't want to intentionally put ourselves behind.
Right.
Right.
Right. We know that's the date, so that's what we need to plan to.
Yeah. Ethan.
And I'm gonna call to the chair that the comment made by Tracy Delphia that we're having a discussion, and if there's any more comments to be entertained about different topics, if not, we should move on.
So yeah, right. We'll be having more discussion about this, but I don't want to cut anybody off because we've warned that we're going to have a joint meeting with the
Presentation
with the planning commission to talk about.
This
It just says joint discussion with the select board presentation about municipal planning in Vermont. We're still talking about. I think we're still talking about municipal planning in Vermont. I would like to entertain. Dawn had her hand up. Do you have a
I'm
question?
good. Nope,
No,
good.
no. We do have one comment from the public.
Oh.
Or another public comment from the public. Sorry, you were also against.
When I attended the governance group that met for, granted it was partly participation of a positive, but part of discussion involved planning commission versus a DRB.
CPA.
Anyway. And what was described at that time was that a planning commission is a body that looks at more long-range planning.
Mm-hmm.
And that the planning commission would be involved more directly and spending more time on the updates of the plan. Whereas DRB would be more what our current planning. And when I looked at the presentation, it didn't look like that at all.
In the presentation we just saw?
Yeah.
Oh, it was very clearly. I thought it was very clearly in there because there were two options that were.
Well, but it just seemed as though there wasn't much interaction between what the DRB does and what some of the other groups do and how it's divided up and how they connect to each other.
Mm-hmm.
And so I'm wondering if there's going to be a possibility amendment, see if that really fits well, or if there is, like you just mentioned, that there's no reason why somebody can't be on both the DRB and commission zoning. It was confusing to me about what the division of responsibilities would be and what the interactions would be. And it sounded more confusing it sounded as if it would be more confusing to the general public in terms of understanding the process and who to go to where. So that's just.
So it'd be it'd be our job to educate folks on how this is all going to work as we figure out how it's going to work and implement it. Yeah.
Well, and ultimately, anything going to the DRB would be funneled through the zoning administrator. So that touch point will not change for applicants. That will still be the process. It'll just be funneled from the zoning administrator to a different body. Am I?
Yeah,
Okay.
correct. Yeah, we haven't talked through how staff is going to break out and
Right.
do the review and all that, but you're right. First staff determines.
So what responsibilities are being directed to another body besides DRB?
Well, there would only be the planning commission and the DRB. So any sort of development
He
application.
had always.
No, he didn't. It was still the same groups.
It was an either or. He was depicting both our current situation and our future situation. There was an implied or there that you either do it this way or you do it this way.
Oh, okay, so the
and-
existing one was there.
Yes.
But they just were.
They've got both options in parallel there, right? And you're right. There was nothing in there that showed how the DRB might feedback information to the planning commission. There's nothing in there about how having your trails and conservation committee review applications as well. So none of the details of how we're going to have this all work were included in his chart, because he's not telling us how we're going to do it. He's just giving the bigger general categories of legislative stuff is taken care of by the planning commission, and quasi judicial is all with the DRB.
That's true.
The zoning board goes away.
Zoning board,
There is no zoning board anymore.
so the zoning board goes.
Yes. So the responsibilities of that the zoning board does today would be done by the DRB in addition to
Oh,
development review.
so that, so.
So all of the
the
quasi judicial
DRB
stuff.
Sort of becomes existing planning commission plus the zoning board.
Except they don't do planning and they don't set regulations.
It's half of the existing planning commission. Planning commission, it wears two hats today. They do planning and they do application review. The application review would fall to the DRB, and Yubi was correct. The zoning board today is 100% quasi judicial. Planning commission is 50%. So the DRB would be 100% quasi judicial. Everything that the zoning board does, all the planning application review would be done by that board. All the planning, straight planning. There's no such thing. All that planning would be done by the planning commission. But all the different details that we've been bouncing around, like the knowledge transfer, the understanding, and also, that all has to be understood, and just at least
And so.
expectations need to be
the-
established.
The current setup will continue those,
Yes.
for the January, or by January.
2025.
Yes. And there has to be, right, how do you deal with applications that are currently in process at that time? We have to understand how all that's going to work. Yes.
Hence the idea of having conversations now.
Yes.
You mean planning?
Like maybe bringing the ZBA in now for application.
Thank you.
There will.
Right.
Sitting at the table like we did that with when it was the village, we would do that with village commissioners. They chose to come over and visit. We would sit at the table and engage in the discussions. Same way to build knowledge. So anyways, different discussion for a different day.
I would just note seeing the happy faces in the back of the room that hopefully the zoning board folks would transfer to the DRB when that happens. Hopefully.
Well, I mean, I think at the end of the day, that's an appointment by the select board, and that would be a decision that the select board would have to make. But it wouldn't automatically happen.
No.
Right.
Mr. Chairman, if there's no other business to come before the select board, I make the motion we adjourn.
Second.
Thank you, Don. Thank you, Ethan. Not debatable motion. All those in favor, please say aye.
Aye.
Opposed, say nay. Okay, Selectboard's
So,
adjourned.
so for the
We've got-
record, the planning commission is still in session. We'll give it 5 minutes to let you guys get out of here.
Thank
Then
you so
maybe we
much.
just have 5 more minutes ourselves.
That's it.
Thank you so much.
Yeah, thank you.
Allowing us to do this.
We have 3 meetings in
How
a
quick
row
we-
in May, and then
We should probably
2 weeks. Okay.
do this.
I got it right in my calendar. Okay.
First, the eighth, a good idea.
Okay, got it.
For a long time, but that's gonna change.
All right. Got it.
6 in a row?
I just wanted to make sure.
Good, excellent. We are back in session. We have a couple things to do. We want to potentially set a date to warn for public hearing.
Yes.
Do you have a proposed time frame on that?
I do. So my hope would be really to have it as soon as possible. And so that would be May 25th. So that would be your second meeting in May.
Okay, so would anybody like to offer a motion to that effect? Which is to warn the, have our public hearing on the packet of zoning and subdivision regulations that we want to move forward on.
May 25th, so moved.
Second.
Seconded by Tom. We're taking a minute. You don't have it yet. Moved by Shu, seconded by Tom. All those in favor?
Aye.
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 That says 4-0.
Thank you.
Minutes. The next item is the minutes from 4/13, and they've been modified a couple times. So I know that the last Sharon sent out something recently. Has everybody seen the versions that she put up? Okay. Does anyone want to offer any? I need a motion on the minutes for 4/13.
Move we approve the minutes for 4/13/2023.
Seconded.
Moved by Shu, seconded by Georgia. Anyone?
If
He said he
everybody
was
really is
traveling.
away,
Dave's away.
we're not.
He was away. Josh might be available for a quick afternoon trip in.
So
Your
what if
call.
you all sign, and then if we can't get somebody in shortly, we'll send it out electronically
Okay.
to start over?
So other business. Do you have anything?
I don't.
Ken?
Nope.
I do. Tom, thank you.
Wow.
It's been an honor, and thank you very much for participating.
Well, thank you for having me, and I really enjoy working with everybody. I'm gonna miss it.
Good luck.
Thank you, Tom.
Yes. Good luck. Good luck.
Thank you.
And with that, I would take a motion to adjourn.
I move we adjourn.
Second.
Oh, Tom seconded. There, he's not getting away. All those in favor?
Aye.
Need one more, Georgia.
Aye.
Thank you.
Thank you.
We are adjourned.